Again, like with the medical marijuana, there were specific employee protections implemented through amendments here to New York Labor Law Section 201D. 201D is a long-standing provision of New York law that generally protects employees' off-duty use of lawful consumable products. Historically, this has included alcohol and tobacco. Sometimes originally this law was referred to as a smoker's rights law, which meant that employers generally couldn't prohibit employees from smoking. But there are exceptions that I'll mention in a second. But the bottom line here is the law now specifically includes the use of cannabis in accordance with state law. So any of those things that the previous slide said were legal, generally speaking, New York employers are now not allowed to use as the basis for adverse employment actions. The law protects employee use of these products, including marijuana and cannabis, outside of work hours, off the employer's premises, and without the use of the employer's equipment or property. So you can still prohibit employees from, to be blunt, smoking pot while at work, which would even include like outside on their otherwise smoke break. And you could prohibit them from doing it, for example, in vehicles that are owned or maintained by the company. What you generally can't do is say when they're outside of work and off premises and not using any company property that they can't generally use cannabis products such as marijuana. Of course, like any good law, there are exceptions. These are the same exceptions in most respects that pertain to alcohol and tobacco use, but there is a specific addition for again, referencing cannabis. So anything that the employer is required to do by state or federal law, they could still do, notwithstanding Section 201D. The employer is also allowed to take any appropriate action when the employee is impaired by the use of cannabis at work, or otherwise where the employer's actions would require such employer to commit any act that would cause the employer to be in violation of federal law or would result in the loss of federal contracts or federal question. It's important to note that, again, you are allowed to take action for employees who are impaired by marijuana at work. The problem becomes demonstrating impairment. The definition of impairment for this purpose is that the employee manifests specific articulable symptoms while working that decrease or lessen the employee's performance of the duties or tasks of the employee's job position, or such specific articulable symptoms interfere with an employer's obligation to provide a safe and healthy workplace free from recognized hazards as required by state and federal occupational safety and health law. Yep. Just before I move on, there is guidance from New York State's Department of Labor on this impairment topic, which unfortunately really calls into question what specific articulable symptoms would sufficiently demonstrate impairment. One thing that the state is clear is that a positive drug test for marijuana would not constitute a specific articulable symptom of impairment because marijuana remains in the system for so long, generally assumed to be much longer than the impairment period. In fact, the New York Department of Labor, as we'll talk about further, has said in essence that in almost all cases, New York employers are not even supposed to be testing for marijuana. But certainly if they do test and find a positive marijuana test, there is generally nothing that employers may lawfully do with that information. The Department of Labor guidance goes on to say that specific articulable symptoms also don't include things like smelling of marijuana, because, of course, one could easily smell of marijuana in an environment where marijuana use is legal, whether or not that person has recently partaken in marijuana themselves and whether or not they are, as a result, currently impaired. Getting back to the now dicier question, in the sense that it's basically the only real exception to the general protection of employees using marijuana, is the issue of what does federal law. The real limited nature of any federal requirements per se is based on some safety sensitive transportation positions that are subject to federal regulations that require drug testing in various circumstances, and the controlled substances by federal statute include marijuana. So if you are in the transportation industry and have people driving certain types of vehicles for commercial purposes, then the drivers and the mechanics and certain other safety sensitive positions connected to those transportation activities may subject those employees to federal requirements, including mandatory drug testing in certain circumstances. And there you certainly could test for marijuana, probably have to test for marijuana to be compliant federally, and then could presumably take the necessary corrective actions that could include discipline, including termination, where there has been peace. There is otherwise something called the Drug-Free Workplace Act, which, since medical marijuana was first permitted, has become a topic of discussion. The law itself does apply to employers with a federal contract worth more than $100,000 or a federal grant, which is a relatively sizable portion of the business organizations out there. So there was an initial thought that, based on the exceptions to these laws, that employers who are subject to the Drug-Free Workplace Act could still prohibit their employees from using marijuana, whether for medicinal purposes or recreationally. However, when you really get into the details of the Drug-Free Workplace Act, there are a comparatively limited number of actual requirements related to the law. Covered employers must adopt a drug-free workplace policy and establish a drug-free awareness program. However, the law clearly does not require any employees to either test for drugs or to fire or otherwise discipline employees who use drugs. In that sense, for example, there is not a direct exception to the 201D protections employees use marijuana have, because, again, the federal law does not require any adverse action based on drug use. What it further requires under this federal law is that employees who must notify their employer within 5 days if they're convicted of a criminal drug violation, but not just any criminal drug violation, a criminal drug violation arising out of the workplace. So, for example, if an employee is arrested for illegal drug use or distribution at work, then that employee must notify their employer within 5 days if the employer is subject to the Drug-Free Workplace Act. And then in that scenario, the employer must notify its contracting or granting agency of this employee violation and somehow penalize employees who violate the policy. Again, there's nothing specifying what those penalties need to be. Therefore, using marijuana, whether it leads to a criminal conviction in some way, shape, or form, or otherwise, is not something that requires that the employee be disciplined, much less fired, even under this Drug-Free Workplace Act. Therefore, accordingly, it's unlikely alone to create an exception for the general protections under Section 201.